The philosophical scripture, Leviathan, is brought to you by not a prophet.org, the place on the internet to find spiritual guidance powered by artificial intelligence. Chapter Roman 23 of the Public Ministers of Sovereign Power. In the last chapter, I have spoken of the similar parts of a commonwealth. In this, I shall speak of the parts organical, which are public ministers. A public minister is he that by the sovereign, whether a monarch or an assembly, is employed in any affairs, with authority to represent in that employment the person of the commonwealth. And whereas every man or assembly that hath sovereignty representeth two persons, or, as the more common phrase is, has two capacities, one natural and another politic, as a monarch hath the person, not only of the commonwealth, but also of a man, and a sovereign assembly hath the person not only of the commonwealth, but also of the assembly. They that be servants to them in their natural capacity are not public ministers, but those only that serve them in the administration of the public business. And therefore neither ushers, nor sergeants, nor other officers that wait on the assembly for no other purpose, but for the commodity of the men assembled, in an aristocracy or democracy, nor stewards, chamberlains, cofferers, or any other officers of the household of a monarch, are public ministers in a monarchy. Of public ministers, some have charge committed to them of a general administration, either of the whole dominion or of a part thereof. Of the whole, as to a protector or regent, may be committed by the predecessor of an infant king, during his minority, the whole administration of his kingdom, in which case every subject is so far obliged to obedience as the ordinances he shall make, and the commands he shall give, be in the king's name, and not inconsistent with his sovereign power. Of a part or province, as when either a monarch or a sovereign assembly shall give the general charge thereof to a governor, lieutenant, prefect, or viceroy. And in this case also, every one of that province is obliged to all he shall do in the name of the sovereign, and that not incompatible with the sovereign's right. For such protectors, viceroys, and governors have no other right but what depends on the sovereign's will, and no commission that can be given them can be interpreted for a declaration of the will. Transfer the sovereignty without express and perspicuous words to that purpose. And this kind of public ministers resembleth the nerves and tendons that move the several limbs of a body natural. Others have special administration, that is to say, charges of some special business, either at home or abroad. As at home, first, for the economy of a commonwealth, they that have authority concerning the treasury, as tributes, impositions, rents, fines, or whatsoever public revenue, to collect, receive, issue, or take the accounts thereof, are public ministers, because they serve the person representative, and can do nothing against his command, nor without his authority; public, because they serve him in his political capacity. Secondly, they that have authority concerning the militia, to have the custody of arms, forts, ports, to levy, pay, or conduct soldiers, or to provide for any necessary thing for the use of war, either by land or sea, are public ministers. But a soldier without command, though he fight for the commonwealth, does not therefore represent the person of it, because there is none to represent it to. For every one that hath command represents it to them only whom he commandeth. They also that have authority to teach, or to enable others to teach the people their duty to the sovereign power, and instruct them in the knowledge of what is just and unjust, thereby to render them more apt to live in godliness and in peace amongst themselves, and resist the public enemy, are public ministers, in that they do it not by their own authority, but by another's, and public, because they do it, or should do it, by no authority but that of the sovereign. The monarch or the sovereign assembly only hath immediate authority from God to teach and instruct the people. And no man but the sovereign receiveth his power de gratia simply, that is to say, from the favor of none but God. All other receive theirs from the favor and providence of God and their sovereigns, as in a monarchy de gratia et regis, or de providentia et voluntate regis. They also to whom jurisdiction is given are public ministers. For in their seats of justice they represent the person of the sovereign, and their sentence is his sentence. For, as hath been before declared, all judicature is essentially annexed to the sovereignty, and therefore all other judges are but ministers of him or them that have the sovereign power. And as controversies are of two sorts, namely of fact and of law, so are judgments, some of fact, some of law. And consequently in the same controversy there may be two judges, one of fact, another of law. And in both these controversies there may arise a controversy between the party judged and the judge, which, because they be both subjects to the sovereign, ought in equity to be judged by men, agreed on by consent of both, for no man can be judge in his own cause. But the sovereign is already agreed on for judged by them both, and is therefore either to hear the cause, and determine it himself, or appoint for judge such as they shall both agree on. And this agreement is then understood to be made between them divers ways. As first, if the defendant be allowed to accept against such of his judges whose interest maketh him suspect them, for as to the complainant he hath already chosen his own judge, those which he accepteth not against are judges he himself agrees on. Secondly, if he appeal to any other judge, he can appeal no further, for his appeal is his choice. Thirdly, if he appeal to the sovereign himself, and he by himself, or by delegates which the parties shall agree on, give sentence, that sentence is final, for the defendant is judged by his own judges, that is to say, by himself. These properties of just and rational judicature considered, I cannot forbear to observe the excellent constitution of the courts of justice, established both for common and also for public pleas in England. By common pleas, I mean those where both the complainant and defendant are subjects, and by public, which are also called pleas of the crown, those where the complainant is the sovereign. For whereas there were two orders of men, whereof one was lords, the other commons, the lords had this privilege, to have for judges in all capital crimes none but lords, and of them as many as would be present, which being ever acknowledged as a privilege of favor, their judges were none but such as they had themselves desired. And in all controversies, every subject, as also in civil controversies, the lords had for judges men of the country where the matter in controversy lay, against which he might make his exceptions, till at last 12 men without exception being agreed on, they were judged by those 12, so that having his own judges, there could be nothing alleged by the party why the sentence should not be final. These public persons, with authority from the sovereign power, either to instruct or judge the people, are such members of the Commonwealth as may fitly be compared to the organs of voice in a body. Natural. Public ministers are also all those that have authority from the sovereign to procure the execution of judgments given, to publish the sovereign's commands, to suppress tumults, to apprehend and imprison malefactors, and other acts tending to the conservation of the peace. For every act they do by such authority is the act of the Commonwealth, and their service answerable to that of the hands in a body natural. Public ministers abroad are those that represent the person of their own sovereign to foreign states. Such are ambassadors, messengers, agents, and heralds, sent by public authority and on public business. But such as are sent by authority only of some private party of a troubled state, though they be received, are neither public nor private ministers of the Commonwealth, because none of their actions have the Commonwealth for author. Likewise, an ambassador sent from a prince to congratulate, condole, or to assist at a solemnity, though the authority be public, yet because the business is private, and belonging to him in his natural capacity, is a private person. Also, if a man be sent into another country, secretly to explore their counsels and strength, though both the authority and the business be public, yet because there is none to take notice of any person in him but his own, he is but a private minister, but yet a minister of the Commonwealth, and may be compared to an eye in the body natural. And those that are appointed to receive the petitions or other informations of the people, and are, as it were, the public ear, are public ministers and represent their sovereign in that office. Neither a counselor nor a council of state, if we consider with no authority judicature or command, but only of giving advice to the sovereign when it is required, or of offering it when it is not required, is a public person, for the advice is addressed to the sovereign only, whose person cannot in his own presence be represented to him by another. But a body of counselors are never without some other authority, either of judicature or of immediate administration. As in a monarchy, they represent the monarch in delivering his commands to public ministers. In a democracy, the council or senate propounds the result of their deliberations to the people, as a council. But when they appoint judges, or hear causes, or give audience to ambassadors, it is in the quality of a minister of the people. And in an aristocracy, the council of state is the sovereign assembly itself, and gives counsel to none but themselves. Chapter Roman 24 of the nutrition and procreation of a commonwealth. The nutrition of a commonwealth consisteth in the plenty and distribution of materials conducing to life, in concoction or preparation, and, when concocted, in the conveyance of it by convenient conduits to the public use. As for the plenty of matter, it is a thing limited by nature to those commodities which, from the two breasts of our common mother, land and sea, God usually either freely giveth or for labor selleth to mankind. For the matter of this nutriment consisting in animals, vegetables, and minerals, God hath freely laid them before us, in or near to the face of the earth, so as there needeth no more but the labor and industry of receiving them, insomuch as plenty dependeth, next to God's favor, merely on the labor and industry of men. This matter, commonly called commodities, is partly native and partly foreign. Native, that which is to be had within the territory of the Commonwealth; foreign, that which is imported from without. And because there is no territory under the dominion of one Commonwealth, except it be of very vast extent, that produceth all things needful for the maintenance and motion of the whole body, and few that produce not something more than necessary, the superfluous commodities to be had within become no more superfluous, but supply these wants at home, by importation of that which may be had abroad, either by exchange, or by just war, or by labor. For a man's labor also is a commodity exchangeable for benefit, as well as any other thing, and there have been commonwealths that, having no more territory than hath served them for habitation, have nevertheless not only maintained, but also increased their power, partly by the labor of trading from one place to another, and partly by selling the manufactures, whereof the materials were brought in from other places. The distribution of the materials of this nourishment is the constitution of mine, and thine, and his, that is to say, in one word, propriety, and belonged in all kinds of commonwealth to sovereign power. For where there is no commonwealth, there is, as hath been already shown, a perpetual war of every man against his neighbor, and therefore everything is his that getteth it and keepeth it by force, which is neither propriety nor community, but uncertainty, which is so evident that even Cicero, a passionate defender of liberty, in a public pleading attributeth all propriety to the law civil. Let the civil law, saith he, be once abandoned, or but negligently guarded, not to say oppressed, and there is nothing that any man can be sure to receive from his ancestor, or leave to his children. And again, take away the civil law, and no man knows what is his own, and what another man's. Seeing therefore the introduction of propriety is an effect of Commonwealth, which can do nothing but by the person that represents it, it is the act only of the sovereign, and consisteth in laws which none can make that have not the sovereign power. And this they well knew of old, who called that nomos, that is to say, distribution, which we call law, and defined justice by distributing to every man his own. In this distribution, the first law is for division of the land itself, wherein the sovereign assigneth to every man a portion, according as he, and not according as any subject, or any number of them, shall judge agreeable to equity and the common good. The children of Israel were a commonwealth in the wilderness, but wanted the commodities of the earth till they were masters of the land of promise, which afterward was divided amongst them, not by their own discretion, but by the discretion of Eleazar the priest, and Joshua their general, who when there were 12 tribes, making them 13 by subdivision of the tribe of Joseph, made nevertheless but 12 portions of the land, and ordained for the tribe of Levi no land, but assigned them the 10th part of the whole fruits, which division was therefore arbitrary. And though a people coming into possession of a land by war do not always exterminate the ancient inhabitants, as did the Jews, but leave to many or most, or all of them their estates, yet it is manifest they hold them afterwards, as of the victor's distribution, as the people of England held all theirs of William the Conqueror. From whence we may collect that the propriety which a subject hath in his lands consisteth in a right to exclude all other subjects from the use of them, and not to exclude their sovereign, be it an assembly or a monarch. For seeing the sovereign, that is to say, the commonwealth whose person he representeth, is understood to do nothing but in order to the common peace and security, this distribution of lands is to be understood as done in order to the same, and consequently, whatsoever distribution he shall make in prejudice thereof is contrary to the will of every subject that committed his peace and safety to his discretion and conscience, and therefore by the will of every one of them is to be reputed void. It is true that a sovereign monarch, or the greater part of a sovereign assembly, may ordain the doing of many things in pursuit of their passions, contrary to their own consciences, which is a breach of trust and of the law of nature. But this is not enough to authorize any subject, either to make war upon, or so much as to accuse of injustice, or any way to speak evil of their sovereign, because they have authorized all his actions, and, in bestowing the sovereign power, made them their own. But in what cases the commands of sovereigns are contrary to equity, and the law of nature is to be considered hereafter in another place. In the distribution of land, the commonwealth itself may be conceived to have a portion, and possess and improve the same by their representative, and that such portion may be made sufficient to sustain the whole expense to the common peace and defense necessarily required, which were very true, if there could be any representative conceived free from human passions and infirmities. But the nature of men being as it is, the setting forth of public land, or of any certain revenue for the commonwealth, is in vain, and tendeth to the dissolution of government, to the condition of mere nature and war, as soon as ever the sovereign power falleth into the hands of a monarch, or of an assembly, that are either too negligent of money or too hazardous in engaging the public stock into long or costly war. Commonwealths can endure no diet, for seeing their expense is not limited by their own appetite, but by external accidents, and the appetites of their neighbors, the public riches cannot be limited by other limits than those which the emergent occasions shall require. And whereas in England there were by the conqueror divers lands reserved to his own use besides forests and chases, either for his recreation or for preservation of woods, and divers services reserved on the land he gave his subjects, yet it seems they were not reserved for his maintenance in his public, but in his natural capacity, for he and his successors did, for all that, lay arbitrary taxes on all subjects' land when they judged it necessary, or if those public lands and services were ordained as a sufficient maintenance of the Commonwealth, it was contrary to the scope of the institution, being, as it appeared by those ensuing taxes, insufficient, and as it appears by the late small revenue of the Crown, subject to alienation and diminution. It is therefore in vain to assign a portion to the Commonwealth, which may sell or give it away, and does sell and give it away when it is done by their representative. As the distribution of lands at home, so also to assign in what places, and for what commodities, the subject shall traffic abroad belonged to the sovereign. For if it did belong to private persons to use their own discretion therein, some of them would be drawn for gain, both to furnish the enemy with means to hurt the Commonwealth, and hurt it themselves by importing such things as, pleasing men's appetites, be nevertheless noxious, or at least unprofitable to them. And therefore it belonged to the Commonwealth, that is, to the sovereign only to approve or disapprove both of the places and matter of foreign traffic. Further, seeing it is not enough to the sustentation of a commonwealth that every man have a propriety in a portion of land, or in some few commodities, or a natural property in some useful art, and there is no art in the world but is necessary either for the being or well-being almost of every particular man, it is necessary that men distribute that which they can spare, and transfer their propriety therein mutually one to another by exchange and mutual contract. And therefore it belonged to the Commonwealth, that is to say, to the sovereign, to appoint in what manner all kinds of contract between subjects as buying, selling, exchanging, borrowing, lending, letting, and taking to hire are to be made, and by what words and sign they shall be understood for valid, and for the matter and distribution of the nourishment to the several members of the Commonwealth. Thus much, considering the model of the whole work, is sufficient. By concoction, I understand the reducing of all commodities which are not presently consumed, but reserved for nourishment in time to come, to something of equal value, and withal so portable as not to hinder the motion of men from place to place, to the end a man may have in what place soever such nourishment as the place affordeth. And this is nothing else but gold, and silver, and money. For gold and silver, being, as it happens, almost in all countries of the world highly valued, is a commodious measure of the value of all things else between nations, and money, of what matter soever coined by the sovereign of a commonwealth, is a sufficient measure of the value of all things else between the subjects of that commonwealth, by the means of which measures all commodities, movable and immovable, are made to accompany a man to all places of his resort, within and without the place of his ordinary residence, and the same passeth from man to man within the commonwealth, and goes round about, nourishing, as it passeth, every part thereof, insomuch as this concoction is, as it were, the sanguification of commonwealth, for natural blood is in like manner made of the fruits of the earth, and circulating nourisheth by the way every member of the body of man. And because silver and gold have their value from the matter itself, they have first this privilege, that the value of them cannot be altered by the power of one nor of a few commonwealths, as being a common measure of the commodities of all places, but base money may easily be enhanced or abased. Secondly, They have the privilege to make commonwealths move and stretch out their arms, when need is, into foreign countries, and supply not only private subjects that travel, but also whole armies with provision. But that coin, which is not considerable for the matter, but for the stamp of the place, being unable to endure change of air, hath its effect at home only, where also it is subject to the change of laws, and thereby to have the value diminished, to the prejudice many times of those that have it. The conduits and ways by which it is conveyed to the public use are of two sorts: one, that conveyeth it to the public coffers; the other, that issueth the same out again for public payments. Of the first sort are collectors, receivers, and treasurers. Of the second are the treasurers again, and the officers appointed for payment of several public or private ministers. And in this also the artificial man maintains his resemblance with the natural, whose veins, receiving the blood from the several parts of the body, carry it to the heart, where, being made vital, the heart by the arteries sends it out again, to enliven and enable for motion all the members of the same. The procreation or children of a commonwealth are those we call plantations or colonies, which are numbers of men sent out from the commonwealth, under a conductor or governor, to inhabit a foreign country, either formerly void of inhabitants, or made void then by war. And when a colony is settled, they are either a commonwealth of themselves, discharged of their subjection to their sovereign that sent them, as hath been done by many commonwealths of ancient time, in which case the commonwealth from which they went was called their metropolis or mother, and requires no more of them than fathers require of the children whom they emancipate and make free from their domestic government, which is honor and friendship, or else they remain united to their metropolis, as were the colonies of the people of Rome, and then they are no commonwealths themselves, but provinces and parts of the commonwealth that sent them. So that the right of colonies, saving honor and league with their metropolis, dependeth wholly on their license, or letters, by which their sovereign authorized them to plant. Chapter Roman 25 of Counsel, how fallacious it is to judge of the nature of things by the ordinary and inconstant use of words, appeareth in nothing more than in the confusion of counsels and commands, arising from the imperative manner of speaking in them both, and in many other occasions besides. For the words do this are the words not only of him that commandeth, but also of him that giveth counsel, and of him that exhorteth. And yet there are but few that see not that these are very different things, or that cannot distinguish between when they perceive who it is that speaketh, and to whom the speech is directed, and upon what occasion. But finding those phrases in men's writings, and being not able or not willing to enter into a consideration of the circumstances, they mistake sometimes the precepts of counselors for the precepts of them that command, and sometimes the contrary, according as it best agreeth with the conclusions they would infer, or the actions they approve. To avoid which mistakes, and render to those terms of commanding, counseling, and exhorting their proper and distinct significations, I define them thus. Command is where a man saith, do this, or do not this, without expecting other reason than the will of him that says it. From this it followeth manifestly that he that commandeth pretendeth thereby his own benefit. For the reason of his command is his own will only, and the proper object of every man's will is some good to himself. Counsel is where a man saith, do, or do not this, and deduceth his reasons from the benefit that arriveth by it to him to whom he saith it. And from this it is evident that he that giveth counsel pretendeth only whatsoever he intendeth the good of him to whom he giveth it. Therefore between counsel and command, one great difference is that command is directed to a man's own benefit, and counsel to the benefit of another man. And from this ariseth another difference, that a man may be obliged to do what he is commanded, as when he hath covenanted to obey, but he cannot be obliged to do as he is counselled, because the hurt of not following it is his own, or if he should covenant to follow it, then is the counsel turned into the nature of a command. A third difference between them is that no man can pretend a right to be of another man's counsel, because he is not to pretend benefit by it to himself, but to demand right to counsel another, argues a will to know his designs, or to gain some other good to himself, which, as I said before, is of every man's will the proper object. This also is incident to the nature of counsel, that whatsoever it be, he that asketh it cannot in equity accuse or punish it. For to ask counsel of another is to permit him to give such counsel as he shall think best, and consequently he that giveth counsel to his sovereign, whether a monarch or an assembly, when he asketh it, cannot in equity be punished for it, whether the same be conformable to the opinion of the most, or not, so it be to the proposition in debate. For if the sense of the assembly can be taken notice of, before the debate be ended, they should neither ask nor take any further counsel. For sense of the assembly is the resolution of the debate, and end of all deliberation, and generally he that demandeth counsel is author of it, and therefore cannot punish it, and what the sovereign cannot, no man else can. But if one subject giveth counsel to another to do anything contrary to the laws, whether that counsel proceed from evil intention or from ignorance only, it is punishable by the Commonwealth, because ignorance of the law is no good excuse, where every man is bound to take notice of the laws to which he is subject. Exhortation and dehortation is counsel, accompanied with signs in him that giveth it a vehement desire to have it followed, or, to say it more briefly, counsel vehemently pressed. For he that exhorteth doth not deduce the consequences of what he adviseth to be done, and tie himself therein to the rigor of true reasoning, but encourages him he counselleth to action, as he that dehorteth deterreth him from it. And therefore they have in their speeches a regard to the common passions and opinions of men, in deducing their reasons, and make use of similitudes, metaphors, examples, and other tools of oratory to persuade their hearers of the utility, honor, or justice of following their advice. From whence may be inferred, first, that exhortation and dehortation is directed to the good of him that giveth the counsel, not of him that asketh it, which is contrary to the duty of a counselor, who, by the definition of counsel, ought to regard, not his own benefit, but his whom he adviseth. And that he directeth his counsel to his own benefit is manifest enough by the long and vehement urging, or by the artificial giving thereof, which being not required of him, and consequently proceeding from his own occasions, is directed principally to his own benefit, and but accidentally to the good of him that is counselled, or not at all. Secondly, that the use of exhortation and dehortation lieth only where a man is to speak to a multitude, because when the speech is addressed to one, he may interrupt him and examine his reasons more rigorously than can be done in a multitude, which are too many to enter into dispute and dialogue with him that speaketh indifferently to them all at once. Thirdly, that they that exhort and dehort, where they are required to give counsel, are corrupt counselors, and, as it were, bribed by their own interest. For though the counsel they give be never so good, yet he that gives it is no more a good counsellor than he that giveth a just sentence for a reward is a just judge. But where a man may lawfully command, as a father in his family, or a leader in an army, his exhortations and dehortations are not only lawful, but also necessary and laudable. But when they are no more counsels but commands, which when they are for execution of sour labor, sometimes necessity, and always humanity, requireth to be sweetened in the delivery by encouragement, and in the tune, and phrase of counsel rather than in harsher language of command. Examples of the difference between command and counsel we may take from the forms of speech that express them in Holy Scripture. Have no other gods but me. Make to thyself no graven image. Take not God's name in vain. Sanctify the Sabbath. Honor thy parents. Kill not. Steal not, etc. Are commands, because the reason for which we are to obey them is drawn from the will of God, our King, whom we are obliged to obey. But these words, sell all thou hast, give it to the poor, and follow me, are counsel, because the reason for which we are to do so is drawn from our own benefit, which is this, that we shall have treasure in heaven. These words, go into the village over against you, and you shall find an ass tied, and her colt, loose her and bring her to me, are a command, for the reason of their fact is drawn from the will of their master. But these words, repent, and be baptized in the name of Jesus, are counsel, because the reason why we should so do tendeth not to any benefit of God Almighty, who shall still be King in what manner soever we rebel, but of ourselves, who have no other means of avoiding the punishment hanging over us for our sins. As the difference of counsel from command hath been now deduced from the nature of counsel, consisting in a deducing of the benefit or hurt that may arise to him that is to be counselled, by the necessary or probable consequences of the action he propoundeth, so may also the differences between apt and inept counselors be derived from the same, for experience, being but memory of the consequences of like actions formerly observed, and counsel but the speech whereby that experience is made known to another, the virtues and defects of counsel are the same with the virtues and defects intellectual. And to the person of a commonwealth, his counselors serve him in the place of memory and mental discourse. But with this resemblance of the commonwealth to a natural man, there is one dissimilitude joined, of great importance, which is that a natural man receiveth his experience from the natural objects of sense, which work upon him without passion or interest of their own, whereas they that give counsel to the representative person of a commonwealth may have, and have often, their particular ends and passions that render their counsels always suspected, and many times unfaithful. And therefore we may set down for the first condition of a good counselor, that his ends and interest be not inconsistent with the ends and interest of him he counselleth. Secondly, because the office of a counselor, when an action comes into deliberation, is to make manifest consequences of it in such manner as he that is counselled may be truly and evidently informed, he ought to propound his advice in such form of speech as may make the truth most evidently appear, that is to say, with as firm ratiocination, as significant and proper language, and as briefly as the evidence will permit. And therefore rash and unevident inferences, such as are fetched only from examples or authority of books, and are not arguments of what is good or evil, but witnesses of fact or of opinion, obscure, confused, and ambiguous expressions, also all metaphorical speeches, tending to the stirring up of passion, because such reasoning and such expressions are useful only to deceive or to lead him, we counsel towards other ends than his own, are repugnant to the office of a counselor. Thirdly, because the ability of counseling proceedeth from experience and long study, and no man is presumed to have experience in all those things that to the administration of a great commonwealth are necessary to be known. No man is presumed to be a good counselor, but in such business as he hath not only been much versed in, but hath also much meditated on and considered. For seeing the business of a commonwealth is this, to preserve the people in peace at home, and defend them against foreign invasion, we shall find it requires great knowledge of the disposition of mankind, of the rights of government, and of the nature of equity, law, justice, and honor, not to be attained without study, and of the strength, commodities, places, both of their own country and their neighbors, as also of the inclinations and designs of all nations that may any way annoy them, and this is not attained to without much experience, of which things, not only the whole sum, but every one of the particulars requires the age and observation of a man in years, and of more than ordinary study. The wit required for counsel, as I have said before chapter Roman 8, is judgment. And the differences of men in that point come from different education, of some to one kind of study or business, and of others to another. When for the doing of anything there be infallible rules, as in engines and edifices, the rules of geometry, all the experience of the world cannot equal his counsel that has learned or found out the rule. And when there is no such rule, he that hath most experience in that particular kind of business has therein the best judgment, and is the best counselor. Fourthly, to be able to give counsel to a commonwealth, in a business that hath reference to another commonwealth, it is necessary to be acquainted with the intelligences and letters that come from thence, and with all the records of treaties and other transactions of state between them, which none can do but such as the representative shall think fit. By which we may see that they who are not called to counsel can have no good counsel in such cases to obtrude. Fifthly, supposing the number of counselors equal, a man is better counselled by hearing them apart than in an assembly, and that for many causes. First, in hearing them apart, you have the advice of every man, but in an assembly many of them deliver their advice with aye or no, or with their hands or feet, not moved by their own sense, but by the eloquence of another, or for fear of displeasing some that have spoken, or the whole by contradiction, or for fear of appearing duller in apprehension than those that have applauded the contrary opinion. Secondly, in an assembly of many there cannot choose but be some interests are contrary to that of the public, and these their interests make passionate, and passion eloquent, and eloquence draws others into the same advice. For the passions of men, which asunder are moderate as the heat of one brand, in assembly are like many brands that inflame one another, especially when they blow one another with orations to the setting of the commonwealth on fire under pretense of counselling it. Thirdly, in hearing every man apart, one may examine, when there is need, the truth or probability of his reasons, and of the grounds of the advice he gives, by frequent interruptions and objections, which cannot be done in an assembly, where in every difficult question a man is rather astonished and dazzled with the variety of discourse upon it, than informed of the course he ought to take. Besides, there cannot be an assembly of many, called together for advice, wherein there be not some that have the ambition to be thought eloquent, and also learned in the politics, and give not their advice with care of the business propounded, but of the applause of their motley orations, made of the diverse colored threads or shreds of authors, which is an impertinence, at least, that takes away the time of serious consultation, and in the secret way of counselling apart is easily avoided. Fourthly, in deliberations that ought to be kept secret, whereof there be many occasions in public business, the counsels of many, and especially in assemblies, are dangerous, and therefore great assemblies are necessitated to commit such affairs to lesser numbers, and of such persons as are most versed, and in whose fidelity they have most confidence. To conclude, who is there that so far approves the taking of counsel from a great assembly of counsellors, that wisheth for, or would accept of their pains, when there is a question of marrying his children, disposing of his lands, governing his household, or managing his private estate, especially if there be amongst them such as wish not his prosperity, a man that doth his business by the help of many prudent counsellors, with every one consulting apart in his proper element, does it best, as he that useth able seconds at tennis play, placed in their proper stations. He does next best that useth his own judgment, only as he that has no second at all. but he that is carried up and down to his business in a framed counsel, which cannot move but by the plurality of consenting opinions, the execution whereof is commonly out of envy or interest, retarded by the part dissenting, does it worst of all, and like one that is carried to the ball, though by good players, yet in a wheelbarrow or other frame heavy of itself, and retarded by the inconcurrent judgments and endeavours of them that drive it, and so much the more, as they be more that set their hands to it, and most of all, when there is one or more amongst them that desire to have him lose. And though it be true that many eyes see more than one, yet it is not to be understood of many counsellors, but then only when the final resolution is in one man. Otherwise, because many eyes see the same thing in diverse lines, and are apt to look asquint towards their private benefit, they that desire not to miss their mark. Though they look about with two eyes, yet they never aim but with one, and therefore no great popular commonwealth was ever kept up, but either by a foreign enemy that united them, or by the reputation of some one eminent man amongst them, or by the secret counsel of a few, or by the mutual fear of equal factions, and not by the open consultations of the assembly. And as for very little commonwealths, be they popular or monarchical, there is no human wisdom can uphold them longer than the jealousy lasteth of their potent neighbours.